Now back to the show. This is The Law Show on CL 650.
Yeah, The Law Show here on CL 650 in studio. We're talking with John Lakes and John White, partners at LakesWhyteLLP, North Vancouver. It's a law firm experienced in estate planning and estate litigation, and we're focusing on the basic rules that constitute a will. Now, I was mentioning during the break, you guys, how long have you been partners?
Well, we've been practicing together in North Vancouver since 1999. Technically, I suppose we've been a partnership since 2002, and we've gone through a number of different versions of our firm, doing different things with different people.
Mm-hmm. It's a good 1-2 punch. One side's the litigator, the other side's the solicitor.
That's been a very stable 1-2 punch, and it really speaks to what people are looking for in our community.
All right. So now, do most of your clientele come from the North Shore? Or do you get people? I mean, you're on the radio here over the whole Lower Mainland. I'm sure you get some people from.
We get some from North Burnaby, sort of East Vancouver, Whistler, Squamish, Seashelt. Actually, we also get people that are referred to us by other people too, who come from other areas.
So that's the best advertising period, is word of mouth, right?
But yeah, the North Shore is. Because of the bridges, we become more and more of an island as well, too. So,
all right. So, the people listening to the show, you're going to take pick a number out of 100%. How many people do you think out there that are of the age group that listen here to see how baby boomers have a will?
I'd say maybe 60%.
Maybe. Wow, that's low. So when people buy a house or have children, don't they think, well, this is the time to have a will? Or
well, nobody expects they're going to die either. So it's something they're going to put off to later, and then there's various circumstances about why they shouldn't do it. And maybe I should have said 60% of current wills, because I do wills where they're totally discurrent. But I'd say maybe 70%. But
now, when you have a will that was maybe written 25, 30 years ago, it's maybe people who were named in the will or have passed on or what have you. So is it still legally binding?
Well, where the problem is that if you've, and John's going to talk a bit about it too, because is if you've named somebody as an executor and they're deceased, then the will is still valid. However, what happens is there has to be an application to appoint what's called letters of administration with wills annexed. So you're saying the will is still valid, but the person who's in charge is either died or incompetent or moved to Belize and resigned, and there's been no backup. And then what happens is that all the residual beneficiaries have a say, but then the whole thing can explode, as John can give you an example right now what we're dealing with.
Well, I mean, it's just it's more proof that if you're going to write a will, you need to think carefully about who your executor is going to be, the person who's going to be charged, or the people who are going to be charged with administering and distributing your estate. My personal preference, just to put it out there, is for one executor. I'm of the view that an executorship is not a democracy.
So you'd rather go by judge than jury, right?
For this purpose, I'm quite okay with a benign dictatorship. I think that's what an executorship should be. I've seen any number of situations where there have been two executors, or sometimes three executors, and they fight. They can't decide on how to administer the estate. And in some cases, that can lead to permanent bad feelings within families, and it's so unnecessary.
Now, to that point, is it good to have somebody outside of the family as the executor? Is it cleaner?
Well, not necessarily. I mean, you need to have somebody who's able to do the task, and can just has the toolkit to actually be able to administer what can be a large amount of money in a manner consistent with what's in the will. I think that person can be within the family as easily as without.
What's the toolkit that you're looking for?
Well,
what would you look for in an executor in your family?
Well, there's a whole list of things. I mean, first of all, how long is the estate going to last? So, for example, typical will, 3 grown kids, mom dies, 1/3, 1/3, 1/3. Well, that will be wrapped up within 2 years, let's say. So first of all, you're going to see who's available. You probably don't want to have anybody who lives in the United States because you could create a double taxation problem. You want to have somebody who's available, so you're not going to appoint your son who travels for business, 9 months of the year. You don't want to appoint someone who's got debt issues themselves. So you have, but then in the other thing, let's say you've got a disabled child, and you're creating a lifetime trust for that disabled child. Well, you may appoint your brother, who's in his 60s now, as the trustee as well as executor. But then you may need to deem a backup because there's a good chance your disabled son will outlive your
That's what I was going to ask, is
Yeah.
what age is the right, I mean, is it people who are younger than you or older?
Well,
or
not necessarily. A lot of that is determined by what the executor is called upon to do. If the executor is going to be called upon to administer a child or a trust for a disabled child for 40 years, then it doesn't make much sense to appoint somebody who's already 60. If, on the other hand, the executor's task is going to be confined to bringing in the assets of the estate, administering them, distributing them, that's something which you would realistically expect to happen over maybe a couple of years.
And now that the example you used of a child that needs care for 40 years, can the executor then pass that on, the baton, to somebody else?
Well, you can do a couple things. So, for example, let's say I have somebody comes in who's got a very responsible 19-year-old daughter. And you may say, all right, I appoint my brother as executor and trustee, but once he resigns or can no longer act as executor, then I've named my daughter as a backup. So you're saying, here is my backup, because
No, but can it be done without that in place? So I'm 60 years old. I am the only executor. Can I then pass the baton? If it wasn't written in the will.
Unless the will lets you to do so, because if you no longer want to act and there's no backup, it's really up to the residual beneficiaries who can decide. And the residual beneficiaries are the people getting the money when everything's gone. So,
right. Their interest is to get the money.
And if you've got somebody with a disability, such as somebody under the age of 19 or somebody's got a disability, then there's an agency called the Public Guardian and Trustee, which is a government agency in British Columbia which looks after the affairs of people who are not competent or unable legally to look after their affairs. So either people under the age of 19 or people that are mentally incompetent. And the PGT would have to approve this as well. So you're getting to a situation where the courts will end up having to intervene, and there could be a dispute, and so it's really important when you do your will to try to have some sort of planning mechanism there, so you're directing who's to be in charge, and you're directing to be who's in charge if something happens to your brother, rather than some judge making a decision, because John's got an example right now of what the judge is making a decision, which is probably not what the deceased person wanted, but it wasn't properly planned.
Well, yeah, and that's fair enough. I mean, I don't want people to think that being named as an executor is an imposition that you have no control over. If you're named as an executor in a will and you don't want to be the executor, you renounce. Which, in other words, resign.
So that person has rights too, right?
Yeah, of course. I mean, you don't have to be the executor, even if you're named as such. Some people consider it to be an honor. Some people consider it to be a duty. It might be an honor. It is a duty, but it's not something. It's not a jail sentence. But in situations where there's only one executor named and that person doesn't want to be executor for good reasons or bad reasons, then that gives rise to the need for the court ultimately to appoint somebody else to act as the executor of the estate. The name that person is given is the administrator of the estate with will annexed. And there's a formula under the Wills, Estates, and Succession Act for essentially who has the priority right to apply to be the administrator, and typically it's somebody with the support of the majority of the residual beneficiaries. But these applications can be contested, and sometimes the court will take a different view of what is best for the estate than the applicant does. And you can wind up with an administrator of the estate who is a very different person or organization than what the testator or will maker would ever have imagined.
So your advice, again, is get your ducks in a row when you're doing your will to make sure you have backup plans for these people.
Yeah, I guess if I were to put it into the 3 points is appoint one executor with a backup, make sure that that person is responsible. I guess those are the 3 points. Somebody who has the ability, the temperament, if possible, the experience, some sort of business experience is definitely an asset here. Make sure that you've got the right person who is, after all, going to be in charge of all of your property with the job of making sure that it goes to the people or organizations that you have said you want it to go to in your will.
Mm-hmm. I mean, one of the things is I'm the one who drafts the wills, and unfortunately for lawyers, we're always doom and gloom. You don't come to a lawyer for a big hug.
Pep talk, yeah.
and I've also, the difference is with a lawyer as opposed to a notary, not only have we been doing wills, but we've also been probating wills as well too. So we find out other people's mistakes sometimes, and therefore it's our job when we're advising people, and of course the person makes the decision, but we say, well, you know, this is what you should do. Perhaps you should name a backup. You want to have somebody who actually gives a damn. I mean, that's a problem if you go ahead and appoint a trust company, or else the PGT takes over. You're dealing with bureaucracy. So most people who act as executors do a good job, and most estates are handled properly. But sometimes you get people maybe overwhelmed. So, for example, you might have somebody who's appointed as their brother's executor, and the brother has very complex income tax matters. Mm-hmm. Well, the person has the right as executor hire accountants to help them. And they've got all those rights to do that as well too, but at least they at the end are still making a decision based on professional advice rather than dealing with a trust company that, you know, they work 9 to 5 and they work, you know, take statutory holidays off and things like that. So the old thing is you appoint someone who gives a damn as the person to be in charge.
What's in a name? We've got 2 Johns here today. John Lakes and John White, and we're going to talk about names and how important a name is when we come back on The Law Show, next here on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.